Good afternoon, everybody, and welcome to today's press briefing. My name is Martin Petrov. I'm the Chief of the Office of the Registrar, and this is Mr. Aleksandar Kontić, Legal Officer in the Office of the Prosecutor. Trial Chamber 1 will render its judgment in the case of Momčilo Perišić next Tuesday, the 6th of September 2011 at 11 a.m. in Courtroom 3. The former Chief of General Staff is the most senior officer of the Yugoslav Army to have been indicted by the Tribunal for crimes committed during the wars in Bosnia and Herzegovina and Croatia. He is charged with crimes against humanity and war crimes, including murder, inhumane acts, and attacks on civilians committed between 1993 and 1995 in Sarajevo, Srebrenica and Zagreb. His trial began on the 2nd of October 2008 and concluded on the 11th of January 2011. The parties made closing arguments from the 28th to the 31st of March 2011, during which the prosecution requested a life sentence, while the defense asked for an acquittal. During the 203 days of hearings, a total of 82 prosecution witnesses and 22 defense witnesses were called. I'll now turn to matters arising from the courtroom proceedings during the last week. During his further initial appearance last Wednesday, the 24th of August, Goran Hadžić pleaded not guilty to all the charges in the indictment. A status conference in the case will be scheduled in due course, and the media will be informed accordingly. In the case of Radovan Karadzic, the accused filed a motion on the 23rd of August requesting the suspension of proceedings for a period of 1 week to allow him to prepare for the testimony of a prosecution witness KDZ 490, scheduled to testify during September. The Chamber denied the motion as it assessed the accused would have sufficient time to review the materials on a rolling basis and also use a scheduled break in the court proceedings in October for that purpose. In line with this, the trial chamber instructed the prosecution not to call that witness before the 17th of October. During the status conference in the case of Ratko Mladić, held last Thursday, the 25th of August, several pretrial matters were discussed, including deadlines for pending motions and disclosure issues. The defense has until today, the 31st of August, to respond to the prosecution's motion to sever the indictment. The pretrial judge also ordered the defense to respond to Radovan Karadzic's motion for access to confidential materials in the case by the end of September, the 8th of September. The next status conference will take place on Thursday, the 6th of October at 2:30 in the afternoon in Courtroom 3. Last Friday, the 26th of August, at the further initial appearance of Šefčat Kabashi, the accused pleaded guilty to charges of contempt of the tribunal. An additional hearing was held later that afternoon, during which judges Moloto and Dalvois both asked to be replaced as judges on the bench in order to avoid any appearance of partiality, as they both are also sitting in the related Haradinaj and others case. An order assigning judges Kwon and Morrison to the case of Mr. Kabashi was issued by the acting president Kwon on Monday, the 29th of August. A further hearing has been scheduled to take place today at 2:30 p.m. in Courtroom 2 for the procedure set out in Rule 62 bis to take place. The purpose of this hearing is for the trial chamber to satisfy itself that the guilty plea has been made voluntarily, that it is informed and unequivocal, and then there is a sufficient factual basis for the crime and the accused's participation in it. In the trial of Zdravko Tolimir, the defense confirmed on Monday that they will not be making a submission under Rule 98 bis of the Tribunal's Rules of Procedure and Evidence. Rule 98 bis provides that the accused may file a motion for a judgment of acquittal on one or more charges in the indictment after the close of the prosecutor's case. After hearing submissions from the parties, the trial chamber can enter a judgment of acquittal on any count if it finds that the evidence presented by the prosecution is insufficient to support a conviction. Tolimir's defense has confirmed that they will be presenting a defense case. Turning now to some current courtroom activity, in the trial of Radovan Karadzic, the trial chamber is currently hearing the testimony of protected witness KDZ 033 in closed session. In the trial of Jovica Stanisic and Franko Simatovic, the trial chamber is currently hearing the testimony of protected witness DST 063, also in closed session. In the case of Zdravko Tolimir, witness Richard Butler, a military expert, will testify this afternoon about the VRS during the operation. In the trial of Haradinaj and Al, the trial chamber will this afternoon hear the testimony of witness 75, resuming his testimony from yesterday regarding the detention of his brother by the KLA in the detention camp Jablanica. In the case against Micho Stanisic and Stojan Župljanin, that case will resume on Monday the 5th of September at 9 a.m. in the morning in Courtroom 3 with the start of Župljanin's defense case. A status conference will be held in the Vlastimir Đorđević case on the 21st of September at 9:30 in the morning in Courtroom 2. I now turn the floor to Mr. Kontić.
No statement from the office of the prosecutor.
Okay. Well, in that case, I open the floor to you. Are there any questions that you would like to ask?
Mr. Petrov, the defense's response to the splitting of the trial in the Ratko Mladic case, the deadline is today, if I remember correctly.
It is.
Will that response be made public? And if it is made public, when will we be able to see that?
I can't think of any reason why the response should be confidential. In fact, I believe the defense will file it publicly. As you pointed out, the deadline is today. So the minute the tribunal receives the filing, it will be made available to the media. Yeah. Are there any other questions? Not really? Okay. Well, then I will turn to two questions that we have received from the so-called interactive press briefing. I think you're aware of the fact that the Tribunal has launched this new initiative whereby journalists from all over the world can ask questions by way of the Tribunal's website, and those questions will be answered at the press briefing that is held on Wednesdays. So we have received two such questions, and I will attempt to answer them today. The first question is, how are persons acquitted by the ICTY compensated? What amounts are paid to them and how they are calculated? The answer to that question is that in the event of an acquittal on all charges, according to Rule 99 of the Tribunal's Rules of Procedure and Evidence, the Chamber will order the immediate release of the acquitted person unless the Chamber grants an OTP motion, a motion by the prosecution, to stay the release pending an appeal. The Tribunal's statute does not, however, provide for compensation to accused persons who have been acquitted by either the trial or the appeals chamber, where the chamber has found that the charges were not proven beyond a reasonable doubt. So in order for such compensation to be paid by the Tribunal, or compensation for say wrongful detention or a wrongful conviction or any other miscarriage of justice, the Tribunal statute would need to be amended. The other question had to do with the Mladic trial, and the question was, when will that trial start? And as we've said many times before, it would be speculative at this stage to try and answer a question like this. The simple answer to the question is that the trial will start when the trial chamber considers the case to be trial ready. There are a number of procedural matters that will need to be addressed before that can happen. Some of them have to do with the preliminary motions that will need to be filed and disposed of by the chamber. Importantly, in this case, of course, the prosecutor has requested the severance of the indictment, and the chamber is yet to rule on that. Depending on the outcome of that motion, there may be one or two trials, and obviously the outcome will affect the scope of that trial or those trials, and in turn the starting dates. Needless to say, whatever the chamber decides will be subject of appeal and may result in an appeal. So at this stage. There are too many uncertainties to answer that question with more specificity. Okay. If there are no further questions, thank you very much and have a nice day.